This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This video will provide a step-by-step guide to completing the Bond Corporate Surety Form, AOC-E-401. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Executor, the person the decedent named in a will to be in charge of the administration of the estate. Administrator CTA, a person who has been appointed by the court to administer a testate estate. This occurs when the decedent has left a will but did not name an executor, or when the person named in the will is unable to perform the role of executor. Administrator, the person in charge of the administration of the estate when no will has been probated. Personal representative, a person who has been appointed to administer an estate. This term may refer to an executor, an administrator, or an administrator CTA. Heir, a person who is able to inherit from a decedent's estate when no will has been probated. Devisee, a person who can inherit from the decedent's estate because the decedent named the person in a will. What is the purpose of this form? This form is used when the law requires that an executor, administrator, or administrator CTA provide a bond to protect the value of the estate's assets. When is a bond not required? A bond is not required from an executor who lives in the state of North Carolina unless the decedent's will requires that a bond be given. A bond is not required from an executor who lives outside the state of North Carolina when the decedent's will waives the bond requirement for the non-resident executor. If the decedent's will does not require that a bond be given, and if the clerk of court does not find that the bond is necessary to protect the estate, then a non-resident executor's bond requirement may be waived if there is a North Carolina resident serving as a co-executor of the estate. No bond is required from an applicant who is the sole heir of the decedent's estate. A personal representative who is appointed solely for the purpose of pursuing a wrongful death claim on the decedent's behalf will not be required to provide bond until the personal representative receives property into the decedent's estate. A bond is also not required of an administrator or administrator CTA who is a North Carolina resident when all of the decedent's heirs or devisees are over the age of 18, are mentally competent, and have submitted written waivers of the bond requirement. The waiver of personal representative's bond form, AOC-E-404, should be used by the heirs if they wish to waive the bond. There is a separate tutorial available for this form. What are the requirements for a personal representative's bond? The amount of the bond depends on the total value of personal property in the decedent's estate and on the type of surety provided. If the bond is provided by a corporate surety company and the value of personal property in the estate is $100,000 or less, then the bond amount must be at least 125% of the value of the personal property. The required bond amount is reduced to 110% of the estate's personal property value when this value exceeds $100,000. The corporate surety company used must be authorized by the Commissioner of Insurance to do business in North Carolina. If personal surety is used, the bond amount must be double the value of the personal property in the decedent's estate. This is rarely used, and the applicant must meet certain criteria before the court will accept a personal surety bond. Please contact our office if this is the type of bond you wish to use. When the bond has been obtained, the applicant will file the bond form with the application and oath affirmation forms. The bond form must be signed by both the applicant and by an agent of the corporate surety company or the persons providing personal surety. All signatures on the form must be witnessed by a person who is authorized to administer oaths. How to complete the bond corporate surety form. Enter the name of the county. Enter the decedent's name. If this is the first bond provided for the estate, enter the starting bond amount. If a bond has already been provided for this estate, enter the last approved bond amount. If a bond already exists for this estate, and this form is being filed to modify the bond amount, enter the amount of the increase or decrease in the bond total. This number should be the difference between the previous bond and the new bond. Next, enter the amount of the new bond. If this is the first time the bond form is being filed, leave these sections blank. Provide the name and address of the corporate surety company. After the form is completed, the personal representative and the person acting on the corporate surety company's behalf must sign the form. The personal representative will sign as the principal. The person from the surety company will sign as agent for corporate surety. Leave the signature portions blank until the signatures can be witnessed by a person who is authorized to administer oaths. This will typically be a licensed notary public. When the form has been completed, it may be submitted with the rest of the applicant's paperwork. The applicant may either bring the document to the Mecklenburg County Courthouse and drop it off, or mail the form to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.